All right. Good afternoon, everyone. Thank you for joining. It is 12:30 here Central Time, 1:30 Eastern Time. So we're going to go ahead and get started with the February webinar. Thank you for joining us, and we'll kind of do some housekeeping stuff to start. So if you've got, colleagues who are still joining, we'll get into the content here momentarily. But let's just kick things off and stay timely. Today's Sanderson Firm webinar is data sharing or data scaring. CMS's new WCMSA exchange with Medicare Part D plans. I will be your MC today. If you don't know me, my name is Annie Davidson. I'm one of the attorneys over here. I am licensed to practice law in Minnesota and handled work comp liability no fault insurance defense before I kind of caught the Medicare secondary payer bug years ago. So today we have Brendan D'Souza joining me as well from Sanderson Firm, our Chief Legal Officer, and Brian Bargender is here with us as well from Humana. So I'm going to turn it over to them and let them introduce themselves. Brendan, do you want to go first?
Sure, I can start. So hello, good morning, good afternoon, everyone. My name is Brendan D'Souza. Like Annie, I'm one of the attorneys at Sanderson Firm. I've been in the Medicare secondary payer space since 2018. I started at a large national provider of MSP services where I cut my teeth on all things MSP, including conditional payments, Medicare set-asides, and Section 111 reporting. So that's a little bit about me, but I am excited that we have Brian here today. He'll be the star of the show and definitely the resident expert in all things Part D. So I'll turn it over to Brian to introduce himself.
Hi, this is Brian Bargender with Humana. I am a management consultant focused on subrogation, Medicare, secondary payer, Medicaid, third-party liability, all of that good stuff. I've been in the industry in this role or similar for a little over 20 years. I've been involved with some of the major MSP litigation for Medicare Advantage plans like Humana versus Western Heritage and a few other cases. And I'm also, outside of Humana, some of the other hats that I wear, I am president of the Subrogation Health Alliance, which is an organization that is devoted to educating health insurance practitioners about subrogation and best practices for Medicare secondary payer and things like that. I also serve on a task group with the National Council of Prescription Drug Plans that has been focused on WCMSA issues, in particular from the perspective of Part D plans and Medicare Advantage Plus drug plans. And that organization's been actively talking with CMS to represent the Part D and MAPD perspective on WCMSAs. So that's how I'm approaching this issue.
In terms of the agenda today, Brendan and Brian will walk you through what's changing, the current process for Part D plan benefits coordination, the new alternative method to coordinate benefits, some additional guidance, and some key takeaways and questions. I will pass it back over to the guys. One of you take it from here. I'll move past the agenda slide and you're on.
Awesome. All right, let's get started. Thank you, Annie. Okay, so obviously what's changing, right? Why are we having this webinar in the first place? So sometime late last year, it would have been mid-November 2025, CMS came out with this memorandum. Specifically, the Deputy Director of CMS's Medicare Part C and Part D data sharing group published a memorandum, which now that I think about it, I'm not sure if this came as a total shock at the time or whether maybe some Part D plans had some advance notice of this, but essentially Medicare issued this 7-page memo, a little dense at points and filled with a lot of jargon, which we'll kind of tease out throughout this presentation. But CMS basically came out and said, hey, look, we know that currently Part D Medicare prescription drug plans only have one way to properly coordinate benefits. And when I say coordinate benefits, I mean, make coverage determinations. So when a Part D Medicare beneficiary presents to their pharmacist to have a prescription filled, Part D plans only have one way to figure out, hey, yes, we as the Part D plan should make payment for this and cover this, or no, we the Medicare Part D plan should deny this prescription drug. And Medicare in the memo basically outlined outlines a new method that Part D plans will have to make these coverage determinations, and it's going to be in the form of a new monthly file. It's going to be called the Medicare Beneficiary Database Other Health Insurance Monthly, or MBDO HIMO. It's a mouthful file where essentially Medicare only once per month is sending information to Part D plans about workers' compensation, Medicare set aside related data. And so the thought process is, now that Part D plans are going to be armed with this workers' compensation, Medicare set aside related data, they'll be able to sort of figure out, okay, what medications were involved in this workers' compensation claim, which had an MSA, which theoretically should allow them to more easily make coverage determinations. So it's an interesting approach, and we'll kind of talk through, okay, is this actually going to be effective, and is this a good thing, or is this a bad thing? So before we dive into all of that, unless Brian has a comment on this slide, we'll dive in just to level set on what the basic what the basic parts of Medicare are, to put this all into context.
Yeah, I mean, let's add a little context for background. So, Brendan, you mentioned that Part D plans might have had some inkling this is coming. I think through the discussion CMS has been having with NCPDP, yes, there were some hints this was coming. This has been going on slowly for years. This memo is interesting because the memo was issued in November. There was an update that was just issued a few weeks ago. Those are the most significant communication directly from CMS to plans in probably 10 years, more than 10 years. And WCMSAs have been a focus for CMS, obviously, if you're on the payer side or a settling party with work comp. It's only been recently, within the last few years, that it's started to percolate to Part D plans, that CMS was looking at changing or looking at more enforcement of what Part D plans were doing. So you might remember the Workers' Compensation Medicare Set-Aside Reference Guide. A year or two ago, CMS put in a provision clarifying what the role of Part C and D plans was. And then they simultaneously put some verbiage into the self-administration toolkit to clarify for Medicare beneficiaries about the role of Part C and D. So this has been kind of developing very slowly, and this memo is sort of and this new file are kind of the cap to it. Although I'm not sure, and maybe we'll have time to get into it, if this is the end of the road, so to speak. I think there are going to be some more developments. But we probably should give some more context just even than that. So let's go on to that next slide. So the types of Medicare: traditional Medicare, Parts A and B, hospital, professional services. Everything about MSP is administered for traditional Medicare by CMS and its contractors. For WCMSAs in particular, that would be the WCMSA review contractor. They make all of the decisions regarding what's going to be approved for a WCMSA, what the policy is as far as the Medicare program overall is concerned. They collect all of the data. That's between CMS, the BCRC, the WCMSA review contractor. All that happens there. Part C and D are Part C is think of it as an alternative way of people accessing those Part A and B benefits. Most plans, probably 90% now, include prescription drug coverage, which would be under Part D. Those plans that have the prescription drug coverage are called MAPD plans. They follow both sets of rules, basically, the regs for Part C and for Part D. All of the MSP for Part C and D is enforced by those plans or their plan sponsors or vendors that work for those plans. They don't collect CMS requires through regulation and the contract with the Part D and MAPD plans that they enforce the same regulations that CMS follows for traditional Medicare. However, the Part C and D plans have no role in determining what should be included in a WCMSA, what should be excluded, what the amount is, any of that. That's all determined by the WCMSA review contractor and by CMS. We've talked about a file that, and we'll get into more detail on that. Aside from setting the rules, the only help that CMS really provides is relaying some data to plans. So Section 111 data that gets captured by CMS through reporting by payers gets passed along to plans, but not even the full data. WCMSA information gets captured by the review contractor, but those files that are collected, all of that information that's collected in that front end process are not passed along to the plans. What CMS does is basically gives portions of the data that it's collecting and portions of the data that it stores in what it calls its common working file to plans. There's a daily file that comes to the prescription drug plans and a monthly file that comes to the Part C plans. Neither of those files, up until recently, has had a whole lot of detail about what's in the WCMSA. Basically, it would just say, there's a WCMSA, here's who the administrator is, and here are the diagnosis codes that are associated with that WCMSA. So from a Part D plan perspective, that's even trickier. For a Part C plan, some of that information can be used essentially as is to coordinate benefits or investigate claims, whatever. There's no crosswalk that's reliable that tells you, hey, these are the diagnosis codes. That means these are the medications that should be considered part of that WCMSA. And without access to that WCMSA detail about the prescription drug history or the drugs that are supposed to be funded, or the amount that's supposed to be funded specifically for drugs and which drugs, that's the dilemma that the Part D plans were in. They were instructed to enforce MSP, especially with respect to WCMSAs, but they didn't have the information to do it, other than there's something out there you need to investigate, go to it.
Well, and if I can jump in for just a second, Brian, you and I have talked for years, especially as fellow Midwesterners. If you don't know, Brian's in Wisconsin and I'm in Minnesota. But we've been doing this a while. And I think that's always been the interesting part, right? Is Medicare has expected you to enforce, but how? And so that's something that I think is, I'm really curious for you and Brendan to keep, plodding along here and telling us like what's going on, because when you talk to CMS about some of this, like, right, I just came up, I'm immediate past president of MSPN, the National Medicare Secondary Payer Network. And as we would talk to them, they're like, yeah, we're going to share some data with the Part D plans, but like whatever they do with it is on them. Like we can't control it. So anyway, this is a very interesting conversation. And thank you so much for that background context, because it's huge. I don't know, Brendan, if you have anything more on this.
No, that was perfect. Brian, you were hitting points that we're definitely going to dovetail more into later. So this is all really good context. So as just to move things along here, for the last context specific slide is just set the legal framework here, right? Where for those who may not be familiar with Section 1862B of the Social Security Act, it makes workers' compensation coverage primary to Medicare. So those in the audience probably are, maybe you don't know it as 1862B, you probably know it as 1395 YB2, otherwise known as the Medicare Secondary Payer Act, right? That's an extension or add-on to their amendment to the Social Security Act itself. And it makes, of course, not only work comp, but liability and no-fault coverage primary to Medicare. We think about, as Brian laid out, the different parts of Medicare earlier, right? You had Medicare Part A and Part B. That was established in 1965. Then we had Medicare Part C, Medicare Advantage plans come along in the late 90s. Then we had Medicare Part D plans, right, specifically for prescription drug coverage. They came in mid 2000s, 2005, 2006. So I guess maybe there was a question on, okay, well, do things operate the same across Parts A, Part B, Part C, and Part D? And the answer is unequivocally yes, right? So Part D plans, just like in Medicare Part A or Part B or Part C plan, they must avoid improper primary payment. And as we'll get into the next slide in the current process and how Part D plans actually coordinate benefits, the law says one thing, but the tools that Medicare Part D and MAPD plans have available to them doesn't necessarily allow them to, recover or not make improper primary payment. So I'll let Brian take the next slide.
So this is the what the current process is, and this process is not going away with this new memo, and we'll get into that later. But there is for everything Medicare related, there is a program manual. There is a specific program manual for the prescription drug plans, and it does spell out instructions for what to do in the case of a record being relayed that indicates there's a WCMSA. Again, I mentioned before, the memo that has just come out, or the two memos that have just come out within the last 6 months, are probably the first significant MSP direction to plans in at least the last 10 years. This process that's outlined currently under Section 5012.1, I believe, is probably at least 10 years old, maybe more like 15. Plans are required to pay for a medication unless they know that workers' compensation is already responsible for that medication. So you have to have some indication that work comp carrier was paying for the medication, or a WCMSA is paid for that medication. Sorry. If you don't know that, the plan is expected to pay the medication up front and then conduct an investigation. And once it determines through that investigation that a work comp carrier or WCMSA should have paid for the medication, at that point, the plan can cut off future payment, or is expected to cut off future payment, and then to attempt to recover payments that should not have been made. And again, with everything Medicare, if it's a primary payers out there, all of the payments are conditional, and they're conditioned on being reimbursed if a primary payer is identified. So that's the process that exists right now, and will continue to exist in some form. Again, plans don't know what is necessarily supposed to be covered unless they have some prior information on this.
And not to further belabor the point or beat a dead horse here, but I just to clarify what you're saying. So for those in the audience, I mean, we're probably all familiar with the WCMSA reference guide, right, which is the Bible on all things MSAs, that CMS updates regularly, multiple times per year. We're also familiar with the NGHP user guide, right, the Bible when it comes to all things Section 111 reporting, and CMS updates that multiple times per year. But it's funny, I go to the chapter 14 of the prescription drug manual, which I assume is the manual that Part D and MAPD plans used to coordinate benefits. I mean, I love that, and it says last updated 2018. I mean, is that correct? I mean, that legitimately has not been updated in almost a decade.
The manual itself, I couldn't tell you. Parts of it might have been updated in 2018. Yeah. The WCMSA direction, I don't think, has been updated since like 2012 or 2013.
Wow. And so that's perfect. I mean, that makes sense and bleeds into just this slide and the next slide on just, I guess, Oh, go ahead. Yeah.
And before you go to that next slide, like, again, let's break this down and think about it. Like, Brian, you do such a good job of like talking about this from your perspective, and but like the thing that comes down to it is like, when any one of us look at an MSA, right, like you can see that there are diagnosis codes that sort of lead you down a path of certain care. So when when our clinical team allocates, it's pretty clear to like read the narrative, watch it, look at those ICD codes. And even with the Section 111 reporting you do, right? You're sending this off to Medicare. You're telling Medicare, here are the ICD-10 codes. That information, if it gets to the Part D plans, is very jumbled via Section 111. And then even if you put an MSA in front of a Part D plan, different
Yeah.
drugs are used for different reasons, and people may have been on some of these drugs before. Their dosage may have changed. What do you do about some of that? Because I've split those hairs. As a former defense attorney, I have 100% written an MSA where this person was on, let's say, an antidepressant at whatever milligram. Let's put them at 20 milligrams. And then they get hurt at work and now they need 30 milligrams. I've written an MSA that only funds that difference of the 10 milligrams because that person is technically responsible for the 20. And then the carrier is responsible for that additional 10. Think about that as a Part D plan. Audience, that's what I'm telling you is like, put yourself in Brian's shoes in terms of, it's just what NDC codes that come through. That doesn't really help a ton. But anyway, I'm getting ahead, but
yeah, you're getting ahead because at this stage, we don't even have the NDC codes.
Correct.
So as part of the WCMSA approval process, the last 2 years of prescription drug history have to be submitted to CMS. That information never gets passed on to Part D plans. So all the Part D plan has to go off of is those diagnosis codes. With the new process, that's going to change a little bit. But so what you'll see, and one other thing we should talk about that I don't think we cover in a slide, but I mentioned there's been discussion between CMS and NCPDP, which further tangent. NCPDP is a industry standards group for the pharmacy benefit industry that acts kind of as a spokesperson for the pharmacy benefit industry, proposes best practices, things like that. So as this WCMSA discussion happened, one of the things that's come out is, and some of you may have already seen this from your perspective, different Part D plans take different approaches to trying to figure out what drugs should be covered by WCMSA. They may send something off to the beneficiary saying, here's your entire prescription drug history over the past year. Which of these drugs should be covered by the WCMSA? Or they might send that to the administrator, or occasionally they'll send that to a work comp carrier or something like that. Or they may just send out a questionnaire that says, we've been told there's a WCMSA, what's it supposed to cover? And that's basically what the current rules require them to do. There might be some technical things that are done a little differently, but on top of that, because that it's kind of the Wild West and there's no best practice that anybody has settled on for how Part D plans should enforce the current rule. Part of what CMS also did that's going to be important to know with these new files is CMS said, okay, and I don't know for sure how long ago this happened, but CMS said, okay, we are going to stop transmitting the WCMSA records to the Part D plans until we get this figured out. And that is, with these new files that we're going to get into, that's being lifted. So you might not, there are some plans that have, we're getting way off track there, but, so different plans have looked at this and said, okay, this is how we're going to approach it. Other plans have said, well, this is impossible to implement. We can't do anything with it. There are others that have said, well, we're getting some of this information through our Part C investigations. So, what a Part C plan would typically do is they're watching, we get that data from CMS that has diagnosis codes. All Part C does, if they don't integrate the prescription drugs, they're looking at hospital claims, physician claims, radiologist claims, ambulance claims, whatever. They can tell this is related to an accident based on the diagnosis codes. They can go to the file that they currently get from CMS and say, aha, this diagnosis code looks like this diagnosis code on the claim. We probably shouldn't pay it, or at least we should investigate this particular claim to see if it's related. And as part of that investigation, they may get to the WCMSA information that also reveals which drugs should be covered. They can pass that on to their Part D counterparts. If it's standalone Part D, they're back to that. We don't have a best practice. All we've got is diagnosis codes and a name. We don't yet current up until recently. And in some cases going forward, we don't get anything that tells us a specific drug that the WCMSA should cover, or a dosage, or a form, or anything like that.
And that's perfect context, Brian. And let's even so as far as process for Part D plans and coordinating benefits, we know the directive that CMS gives is, hey, Part D plans, PD plans,
Mhm.
close your eyes, cover your ears. If a Medicare beneficiary comes in and they've got prescription drug coverage, just pay automatically, and you know what? It's on you. Figure it out on the back end on whether this should be denied or coordinated in the
Mhm.
future.
Mhm.
And so I guess in this slide, it's like, okay, well, how do Part D plans actually make that analysis? And CMS, we know that there's this daily coordination of benefits other health insurance file, the COBOHI file, which Part D plans have, and includes information about the administrator's name, their contact information, settlement date, diagnosis codes, everything except for prescription drug information. So as I think as
Mhm.
mentioned, right, Part D
Yep.
plans they're aware that a Medicare set aside exists. They're aware that it's settled, but they don't really have prescription drug information. And then, okay, it then falls on the plans to reach out to administrators. And so I guess one of my questions is, how effective is this? And I guess this bleeds into the next slide, but how effective is this? I mean, how accurate is the information? Are you always getting the administrator's information? And if you are, zero being okay. We have the information. We've reached
Mhm.
out to them, and yeah, or no, no, but they won't respond to us. Or 100 being,
Mhm.
100% of the time we have all the info, it's accurate, and we're actually able to coordinate benefits. Like, how does this is this actually effective in practice, and how reliable
It
is the data?
mm, it works ish. um, so the data, especially when CMS started looking into so my understanding is this a lot of the discussion started because CMS was conducting audits of Part D plans, and they would look at a record in a they look on a claim by claim basis. They say, why did you pay for this medication when we gave you a record that there's a WCMSA? And the plans had to say, well, we couldn't determine if it was related or not. Well, what steps did you go to? All of that. So the uh, the data feeds kind of cluttered. Another issue is 90% of the time, or at least 85% of the time, from the little data we do have, there is no professional administrator involved in the WCMSA. So um, you have two paths. You can contact the administrator, some of which are very responsive, others are not. Um, or you can contact the beneficiary, who, especially if the WCMSA is older, they have no clue where any of the paperwork is. They don't know what a WCMSA means anymore in some cases. If it's a WCMSA that was just established within the last year or two and they're self-administering, they probably have all of that information. If it's 5 or 6 years old, and as far as CMS, or 10 years old or older, and as far as CMS is concerned, it hasn't been depleted, they may not have this information. So you're not going to get very good response. And one of the things that this is a thread the needle type process. So CMS wants these WCMSAs investigated, but CMS and plans, really, to be honest, are very, very concerned about access to care. Nobody wants to deprive a beneficiary of medications they need, because that's going to increase costs down the road, not to mention harm the beneficiary. So the instruction from CMS is, and this kind of gets to Annie's point about the medications that are used for both a pre-existing condition and maybe a exacerbation or something like that. The rule is, if the medication is exclusively for the work-related injury, then it should not be covered by Medicare. If it covers, it might be something like, I don't know, like a hydrocodone or a Vicodin that's for your work-related knee injury, but you're also taking it because you've got degenerative changes in your spine. Right, we'll just use that as an example. If it's treating both work-related and non-work-related injuries, the current standard is it gets paid, and you don't worry about recovery on that. You just have to verify that. But
Wow.
this whole process with the bad data and the contacting a self-administering beneficiary that maybe doesn't understand the process or forgotten a lot of it, that also, that the other thing that plans are worried about is, to some extent, beneficiary attrition, but also complaints to CMS. If a plan does not enforce the MSP rules for Part D, they can be dinged by CMS for an audit and face some financial penalties. If they do the investigation and make a good faith effort based on what's the limited information CMS provides, some beneficiaries will leave. And our internal research is that the false positives generate more member attrition than the accurate guesses, so to speak. So if I reach out to somebody because they have a WCMSA and they know that it should be covering drugs, it's generally not a problem. It's when the beneficiary, we receive a record that's maybe out of date, or that the beneficiary doesn't understand the process or something like that. Or it could be a record where it's been exhausted and just not properly reported to the Part D plan by CMS. That's going to lead to complaints and beneficiary attrition. And the plan cannot avoid those. We cannot go to CMS and say, we're following your process, don't penalize us for this complaint. That's not an exception. If you follow the rules and it generates some heat, you're going to be dinged. If you don't follow the rules and CMS finds out in an audit, you're going to be dinged. So you're between a rock and a hard place.
Yeah. So we understand the current process, the pain points of that, and so of course we have this brand new file, this new monthly file. For the sake of time, I guess we can skip this slide, but I'll let Brian sort of explain the detail of specifically what information is now being told to Part D plans through this new MBDO file.
So in addition to that daily Part D file, we are now getting a monthly file from CMS, which is delivery has just started. I have not had a chance to even dig into it yet, but it will be a monthly supplemental file that ties into the daily file. It provides the beneficiary identifying information so we can link back to the master file that we're already getting. It will have the WCMSA control number if one exists, and presumably for all submitted and approved WCMSAs, there should be one. It will tell us is funding lump sum or annuity, which is something we didn't know until now. And it will give us up to 12 of the NDC codes. So if you're not familiar, an NDC code is a very specific code that identifies not only the drug, but the manufacturer, the strength, the dosage, the format, if it's, say, caplets or syrup or pills or whatever, and the package size. So there's 200 caplets versus 50, and they're all this dose. What that can be used for then is to at least get in the ballpark of which types of medications are being used. But CMS kind of went into, so one of the questions that plans had been asking when this discussion started in NCPDP was, are we only supposed to deny if we see the specific NDC code? And that's not clear in the current guidance. So a situation would develop where, kind of similar to the example Andy was given, you might have a drug where the person is, the WCMSA, it clearly is funded for a 50 milligram dose. Okay, so you deny that NDC code when you find out that's what the WCMSA funds. Well, what happens if the person then, or somebody changes dosage and it becomes, let's say, 100 milligram dose. Or what if, to get around a claim denial, they start taking 225 milligram pills instead of 150? That's a different NDC code because that's how specific NDCs get.
Mm-hmm.
So this gets us in the ballpark. It allows us to say, okay, clearly some of these drugs that we do not have anything to do with the WCMSA, let's make sure those get paid and processed correctly. And let's worry about the ones that we really need to worry about so we can focus things a little bit more.
Yeah, and just, oh, you're gonna say something, go ahead.
Yep. Oh, and then this slide. So what we're also allowed to do is now, rather than waiting until we get a response from the administrator or the beneficiary, we can use point of sale edits based on the NDC code. That could mean either, if you have a drug that matches, that's your evidence that work comp should be accepting. And you can deny that particular medication, or you can require pre-authorization to get it processed. It does not have to be the exact NDC code. So that 25 versus 50 versus 100 milligram problem, in theory, goes away. And not only that, you're using the RX norm standard that CMS uses for some other things with pharmacy formularies and things like that. And I think on the next slide, or one of these slides, we explain RX norm a little bit more. But basically, there we go. So it's a standardized system for describing the ingredients that are in a medication. It's not down to specific packaging or dosage or manufacturer. In the case of, it's like a hydrocodone, it would be that codeine component, or maybe Tylenol, whatever it would be. But if that's the active ingredient in the drug, and it matches the active ingredient in that NDC code that's reported, a plan could block payment or require pre-authorization for everything that's related to that ingredient in another drug as well. And it's a system that Part D plans already use for reporting their formularies to CMS and getting approval and stuff like that. So it's not a new standard for Part D. This is a very, very new application for that standard, though.
Perfect. And just let me just clarify, I guess, clarify one point, and then maybe ask a question. So yeah, because we're kind of talking about, NDC codes versus the traditional way, I guess, versus NDC codes on this new alternative method. So under this new alternative method, should Part D plans choose to use it, right? Part D plans can't just reject the exact NDC code provided on the monthly file. They have to apply these, and goes to the other question, but they have to apply point of sale edits to all NDCs corresponding to that specific RX norm or active ingredient. So if you have a Medicare beneficiary on a Part D plan, and the Part D plan knows through this new alternative file that she has a work comp MSA with oxycodone, and whatever NDC code is attributable to that specific dosage and frequency and supply of oxycodone, the Part D plan then actually has to reject all oxycodone products for her, regardless of manufacturer, package size, all that stuff, since they share the same active ingredient. So essentially, this prevents the unscrupulous actor or the Medicare beneficiary from saying, oh no, hey, like, I've got my Medicare set aside funds, and I actually like this money. I like this safety net. I want to preserve it as much as possible. So yeah, I'm using oxycodone, but I'm actually going to go to my pharmacist. I'm going to have them fill the same medication, but just a different fill or size, such that my private Medicare plan makes payment for it, even though my MSA actually already has this covered. So yeah, so that, just to confirm that one point. And then also a question.
I want to clarify, though. It's an option for the Part D plan.
Correct. Yep.
So it's not that they must.
Right.
It's an option for them And it does clarify the existing process a little bit, but it is the key point is that an NDC code is specific to a single medication. It's this brand and this package and this dosage. That's that's that code. An RX norm is potentially hundreds of drugs, or whatever, versus just a single pill or format.
Perfect. And thank you for that. Other maybe slightly unrelated is there's one of the things that I maybe don't like about the memo that CMS published announcing this new change, at least for me, because I'm not in the weeds of Part D, but there's a lot of jargon in there. For example, there's a lot of point of sale and point of sale edits. Can we maybe use an example of how is this actually going to work in real life for the audience and for me? So I mean, let's say
that's a great question. I have the same question. How is this going to work? So point of sale means the pharmacy. So mail order is one thing, but the image that I have is a Medicare Part D beneficiary walking up to the counter at their local Bob's Pharmacy, Walgreens, CVS, whatever, and saying, I have this prescription that needs to be filled. How is this going to work? The shorter answer is nobody knows. And because until recently, there was no industry standard for how Part D plans should communicate with the pharmacist regarding a WCMSA. That has changed literally within the last week, but it hasn't been implemented. So I mentioned NCPDP does these industry standards, among other things. So a voluntary industry standard was approved within the last week for communication between the Part D plan sponsor or their pharmacy benefit manager and the pharmacy at the point of sale to say, hey, this medication should be covered by a WCMSA. And here's a specific universal code that would be communicated to the pharmacy at that point to say the Part D plan shouldn't be paying for this based on that investigation that's been done. Now, there's a lot of other stuff that has to be defined in logistics that support that code. But one of the things with it is it also provides a mechanism for the pharmacy to say, we think that's a mistake. CMS is very clear, and the Part D plans are all very clear. We do not want to be denying things we should not be denying, or require. We don't want to prevent somebody from getting the care that Medicare is supposed to cover.
Right, and I think that gets to the point in your guys' very clever title of data sharing versus data scaring, because I think the reason why this is topical, right? So I find this fascinating. I think a lot of us nerds in the Medicare secondary field find this interesting. But when you sort of zoom out of this and you look at the overall MSA industry, this gets scary because of what you just said, Brian. Yes. Nobody exactly knows how to do this. And when we think about it, there's probably not a lot of trial lawyers on this call right now. If there are attorneys, they're likely defense. But, I work with folks on both sides of the aisle. I speak to trial lawyers, I speak to defense attorneys. Anything that happens, and I think this is a more nuanced point to a point that you're not, specifically, you're calling it out by saying attrition. But, if we say that more quiet part out loud, this creates friction and barriers to people, right?
Yes.
If having an MSA makes their life that much more difficult to get their drugs filled, that means that how many more people are actually going to agree to settle out their cases with MSAs? And I think
Mhm.
that's the larger part that's like why I think this is scary. And I think it's something it's worth talking about is
Mhm.
yes, Medicare Advantage plans worry about attrition. They worry about beneficiaries calling and complaining about their benefits, right? What do we mean by attrition? We mean they leave Humana and they go to some other plan and they
Mhm.
hop around from plan to plan, or they go back to traditional Medicare Parts
Yeah.
A and B. But you have to have a D plan if you want, your drugs covered. So, the industry that you're talking about, Brian, is worried about that. And then that's it, is the industry. Then there's a downstream effect to the overall WCMSA industry, which
Mhm.
is how do you get people to still agree to these? So it's very important that whatever happens, there are the industry norms that you're talking about, Brian. There's ways to be able to message it and not make it too, to the point that there's some friction. Can it
Mhm.
be, dispelled rather quickly? Especially when I think about, let's say I had an MSA and then I have an intervening superseding injury, right? Where
Mhm.
something else happens. Okay, fine. I'm denied at Costco where I go fill, but I can quickly then say, no, this oxy that I need is for a car accident that it's not my work injury. I was just in a motor vehicle accident
Yep.
last month and I need this for
Mhm.
this. The idea
Yep.
then is hopefully that can be cleared up very quickly so that person goes on their way. I walk out of Costco with my oxy, which I try never to
And
take
yeah,
oxy,
and
but yeah.
I do think that is definitely one of the goals that CMS has, and really most plans have that too, because especially with MAPD, if you deny something that you should have paid for, you're going to pay more down the road.
Yeah.
And just to put it in stark business terms, um, the and the whole goal of Part C, Part D is the prescription arm. The whole goal of Part C when it was created was to figure out a way to deliver Medicare benefits in a better way than traditional Medicare. And if you are denying coverage and increasing the expense that you're going to pay, you're not doing good by the beneficiary or by from a business sense. We really want to pay the right claims the right way the first time we see them. We don't want to be chasing things down. We don't want to be denying something and that we shouldn't have, and then reprocessing. And we want this to work well for everybody.
Yeah, and I think Annie raises a brilliant point. I didn't even consider that,
Mhm.
right? Like that friction of this new
Mhm.
alternative method, and maybe it makes plans more susceptible to false positives or false
Mhm.
denials. And just so the audience knows, right? Maybe this is something that's not widely adopted by Part D plans, right? Because this is totally optional. Part D plans can choose to use this information to
Mhm.
make coverage determinations, or they can say, tech with this is too unreliable. We don't feel comfortable. We're just going to continue to pay conditionally for everything that comes in the door, and we'll reach out in the back and then try to figure out whether
Mhm.
that was acceptable or not. So yeah, really, really great
But
point.
yeah, but I think that question's really out there. Is what are plans going to be doing with this new option? But in the background, all of this data is coming, and CMS is now, that the bear has awakened, so to speak. They are saying, with this memo, we expect you to be doing something with WCMSAs, whether that's the old process or the new process. I think if you are settling work comp claims, or you're an administrator, or somebody that works with a beneficiary, you ought to expect to see more activity from Part D plans than you're used to.
Well, and then that's it is so we've kind of I've displayed some slides that we've been talking about, but we didn't specifically, we're not going to read you every single slide. You'll get a copy of this. So I think the slides have kind of shown some of that. I
Mhm.
guess what's the alternative? The alternative is then going and using an old conditional payment method, right? Like how
Yeah.
Yeah, the old it's basically you either all to me the difference is we now have the NDC codes that will refine what we can do with the old method, whether or not we choose to block payment going forward. But we still have to do the old method. Now, here's where we're getting short on time, I think.
Yeah.
So I do kind of want to jump a little bit.
Yeah.
In terms of two things that people should be scared about. One is, what about these non-submit WCMSAs? We're not going to get NDC codes for that. The question is, at what point is CMS going to start relaying the records they're collecting through Section 111 to the Part D plans? And all signs point to they're going to do it. I have not seen this latest file, so I don't know if any of that information for non-submits has started to arrive. But if it isn't in this new file, I think it's coming. And one of the other issues for plans deciding how they're going to choose is we have no idea how many WCMSAs we're going to be looking at, partly because the non-submits, we have no idea how many non-submits there are that are collected for Humana members through Section 111. And it's also been a few years since we've been getting all of the submits. So we don't know how many records we're dealing with. We don't know what percentage of those will have the NDC codes. So all of that goes into, for every Part D plan, deciding what are you going to do with this new option.
Yeah. But, go ahead.
And this kind of goes, let's go back up to that slide. So we got the summary of the memo and all that, but so what was an attestation? When that memo came out in November, we thought it was a copy of the annual attestation or the exhaustion paperwork that had to be submitted with CMS. It is something less exacting than that. Basically, it's if the beneficiary tells the pharmacy or tells the Part D plan, this shouldn't be covered by the WCMSA because of X, that's supposed to be good enough. Here's where the honor code issue comes in, because some percentage of people may be tempted to say, nope, the WCMSA is exhausted, or it never covered this drug or whatever. They still have to report to CMS their attestation. It partly, short term, maybe it doesn't have an impact, but if they do move from Humana to a United to a CVS or back to traditional Medicare, that WCMSA record is still listed as active in CMS's common working file. So they're going to have to go through this whole process over again with a new Part D plan sponsor. And worse, if they do provide false information to the Part D plan sponsor, the Part D plan sponsor is obligated to report that to CMS. Wow. CMS then makes a determination on whether all Part D benefits should be terminated. So not providing accurate information about the WCMSA to the Part D plan potentially puts all Part D benefits at risk. It's not a question of this drug won't be denied, whether or not this particular work-related injury drug will be denied. It's, will your insulin be covered? Will your heart medication be covered? And that decision is out of the Part D plan's hands.
And that's scary. That's very scary. Yep. All right. So
I think the one of the things that I do see as something that's likely to be happening, regardless of what the Part D plans do, I think there's going to be an emphasis on education from at least some of the plans.
And I think you're right, Brian, because when we talked about this at the National MSP Network last year a bit, I know the MARC Coalition had met with you all and talked with you a bit about this too, but everything I was hearing from CMS last year was that they're going to watch what's happening and what you do with the data and how it sort of transpires. So I think it's we don't ever want to just scare people and say the sky is falling, the sky is falling. Like this, I think we're in a space of gathering information and testing some things out. And as scary as that is to trust a federal agency, right, with walking that path with you, for all intents and purposes, it does seem to be that's what they're saying. So we have
Yeah.
some key takeaways here for you, and some kind of open-ended questions. Thank you so much, Brian, for kicking off this conversation. With that, we don't have a ton of time for questions. Thank you so much for your attention. Oh, and I realize it doesn't have their contact information, so we'll make sure that we can get that out to you when we send you the information. But again, this isn't legal advice too. And I'm sure Brian issues the same disclaimer. He's not like
Oh,
speaking
yeah.
for all of Humana and all of the PD plans.
Exactly.
Exactly. So yeah, I don't know if there's any questions that you all saw come through that you want to answer here in the
I
last
have not
minute.
seen anything.
I haven't either. I think we've, really stumped our audience with this, or we've scared
So,
them. They've come
I
away very
guess-
scared.
So I will ask a question on behalf of the audience. Okay. If I am somebody dealing with WCMSAs, what should I do with this information? And this is a selfish answer, but I would say be proactive. So one of the lessons that I hope you would have learned from the PAID Act is when you have the information about who that Part C or D sponsor is, it can be very helpful to contact that Part C or D plan before you settle a claim, whether it's a liability claim or disputed work comp. I would suggest you give some thought to, if you already know, especially somebody who's a Medicare beneficiary already, use your PAID Act information and say, hey, there's going to be a settlement that may include a WCMSA. What information can we provide to you now that's going to make things easier for this beneficiary down the road? Consider doing that. I don't know if there's any reason why you can't, but at least give that some thought.
Well, with
Great.
that, we will wrap it up. Yeah, thank you guys both so much. And thank you everyone in our audience for attending. On behalf of Heather and everyone at Sanderson Firm, we thank you and hope to see you next month. Take care.
Thanks,
Bye,
everyone.
everyone.
Bye.
Okay. Bye.